Good afternoon, everyone. For those just joining us, we're just waiting for everybody to be able to be admitted. We'll start very shortly. Good afternoon, everybody. I think we'll make a start. I'm Schona. I am chair of the Bar Human Rights Committee of England and Wales, and I am absolutely delighted to have with us today Her Excellency Ms. Nazhat Shameem Khan, President of the Human Rights Council and Permanent Representative of the Republic of Fiji to the UN in Geneva. Ambassador, it's a pleasure to have you with us today. And for those of you joining us, this is one of the events that we've done this year for BHRC, hitting 30 years old this year. So we intend just to have a few, I just would like to introduce the ambassador, and just so that you know the format of today, we will be doing an in-conversation and followed by a Q&A. So you're all very warmly invited and welcome to ask questions directly into the Q&A. Ambassador Nazhat Shameem Khan was appointed to Fiji's permanent mission to the UN and other international organizations in Geneva as their permanent representative and ambassador when it first opened in April 2014. Ambassador Khan was born in Fiji and holds a Bachelor of Arts degree in law from the University of Sussex, a Master's of Law degree from the University of Cambridge, and a Master's of Philosophy degree in Criminology from Cambridge University. She was called to the Bar of England and Wales in 1983. I think she's a member of Inner Temple, and she was admitted as a barrister and solicitor of the High Court of Fiji in 1984. She practiced as a Crown Prosecutor at the Office of the Director of DPP from 1984 to 1994. In 1994, she was appointed to the Director of Public Prosecutions of Fiji, the first woman to be so appointed. In 1999, she was appointed Fiji's first woman High Court judge, a position she held until 2009. Whilst holding judicial office, she delivered a number of human rights decisions, applying international human rights law in decisions on prison conditions, mandatory minimum terms of imprisonment for drugs offences, and the rights of persons accused of criminal offences to counsel. She also introduced for the first time in the Fijian courts principles of sentencing, which were enacted in Fiji's first Sentencing and Penalties Act 2009. She also introduced case management in the criminal jurisdiction of the High Court of Fiji and led initiatives for judicial training programs for judges and magistrates. As a private practitioner from 2009 to 2014, she conducted legal and corporate training for judges, lawyers, and the business community on human rights, corporate and good governance, gender and access to justice, and on litigation skills. She continues to conduct ethics training for new legal practitioners in Fiji. Ambassador Khan also co-chaired the technology stream of the Human Rights Council's efficiency process in 2018. She's a strong advocate for more Pacific Islands and SIDS to become members of the Human Rights Council, to making it more inclusive and representative. During Fiji's first year as a member of the Human Rights Council for the 2019 to 2021 term, Mrs. Khan was nominated to be Vice President of the Council by the Asia Pacific Group. She chaired the Human Rights Council Task Force on Accessibility for Persons with Disabilities, and during her tenure created the group of Friends of the Task Force dedicating to furthering its work. In 2020, Ambassador Khan was appointed to as co-focal point to address challenges faced by delegations from small and developing countries, in particular SIDS, LDCs, and follow up on the implementation of measures on the use of modern technology at the Council. These responsibilities became especially important during the COVID-19 pandemic. In January 2021, Ambassador Khan was elected President of the Human Rights Council for 2021, a position she holds until the 31st of December. Ambassador Khan, it's a total pleasure and privilege to have you with us today. Thank you very much for joining us.
Thank you very much indeed.
Ambassador, as you come towards the end of your term as President of the Human Rights Council, how do you view the international human rights landscape, perhaps first as a lawyer yourself, and then, of course, as the President of the HRC?
Thank you very much. And may I say what a pleasure it is to join this fireside chat and to have the opportunity to talk about the Council and human rights generally. I have to say that at two levels, I think there is a great reason to celebrate. One is that domestically, there has been a far greater translation of the work of the human rights mechanisms of the Council and the treaty bodies and of conventions to the domestic landscape. So far more, I think, work has been done on the implementation of human rights at every level domestically. I think this is room for celebration. I think it shows how hard field officers of the OHCHR have worked in implementation, and also how relevant the Council continues to be as it is more and more representative in its membership and in the way in which it delivers to individual countries. Speaking of the Council itself, I think in many ways the discourse on several human rights issues has really advanced. And I talk specifically, for instance, on the discussions around the death penalty, around sexual orientation. I think that there is a much better discussion now on reprisals and the prevention of them for those who participate in the Council and for those who support the work of the Council. And I think there is a very, very strong discussion now and greater support for the protection of human rights defenders in the Council. So certainly, I think thematically, the human rights discourse has become stronger, more principled. I think that the special procedures have done a great deal of work to ensure the relevance of the discussions we have. So for instance, very quickly, the special procedures mandate holders, many of them, delivered statements and reports on the relevance of COVID-19 to their specific rights in the course of last year and this year. And really does show the flexibility of the landscape. And I also think that we should celebrate the Universal Periodic Review of the Human Rights Council. This is a process by which there is a peer review of every United Nations member state in the UPR. So this is not just confined to member states of the Council. And I think it's an equalizer. It's extraordinary to sit there and hear recommendations from states to countries which include Guinea, as well as the United Kingdom, the United States, and Germany, as well as Nauru and Kiribati. So I think this is an equalizer, and the UPR has become stronger in the years that I have spent working at the Council. Over to you, Schona.
Thank you very much. Ambassador, you talked about the strengthening of work in areas as different as the death penalty, but also sexual orientation and the protection of human rights defenders. And I would be interested to know how you feel the work has progressed in terms of sexual orientation. How do you measure that progress? What's happened to make you feel that the dialogue has shifted?
Well, firstly, I think the Human Rights Commission, which preceded the Human Rights Council. The Human Rights Council replaced the Commission in 2006. I think that the discussion and debate around sexual orientation has changed. I think that there is a greater acceptance of sexual orientation as a component of the recognition of gender equality, but as well as a right in itself. And in the two debates leading to the adoption and the extension of the SOGI mandate, which is a mandate created to prevent violence and discrimination against persons on the ground of sexual orientation, that debate has seen, I think, a greater ease, a greater acceptance. And more countries, I think, have accepted the mandate. Originally, I think it was very controversial. It was very difficult for some countries to accept. Often countries said that this mandate was contrary to their religious values. I think because the language is couched in terms of non-discrimination and non-violence, I think there's a greater acceptance of this mandate and therefore of the work of the mandate holder. The second thing I think is that the Human Rights Committee has now defined gender and gender equality, because of course sexual orientation was not in the Universal Declaration or in the ICCPR. This is really an evolving concept of equality. But the Human Rights Committee has really helped us to understand that sexual orientation, gender identity are included as a component of gender equality, which is in ICCPR and the Universal Declaration. And that in its turn has translated into the body and the text of many national institutions and national constitutions as well. So the judiciaries in many countries are now defining the scope of what sexual orientation means, how it overlaps with rights to privacy, and how it really relates to a state's right to have criminal justice laws, for instance, on sodomy. So I think there's been a lot of progress in this area.
One of the things that's interesting about this specific conversation, this aspect of human rights and equality, is that you're talking about sort of a range of progress, perhaps over 10 to 15 years, that one's seen a shift in national constitutions, but also national jurisprudence relating to, for example, sexual orientation. What role do you think that the UN institutions play in the changing dynamics of that conversation? And do you think that, for example, on the Human Rights Council itself, where there are members with a very diverse range of views, some which might be perhaps opposed to a greater to greater progress in some of those areas, such as sexual orientation. How do you think that has impacted on domestic conversations? So the international landscape affecting domestic conversations.
I think there are a number of domestic jurisdictions which specifically empower judges to interpret their constitutional provisions in the light of international law. And many of the more progressive judiciaries have interpreted that to include recommendations made by treaty bodies, for instance. And one example is General Comment 32, which is specifically about the right to a fair trial, issued by the Human Rights Committee, and which really looks in detail at what the right to fair trial means and how it translates in relation, for instance, to legal aid commissions, or the right not to be represented by counsel, if that's your wish. So it's extraordinary the way the treaty bodies have really responded to some of the big questions asked by legal professions, for instance, around the world. And if you have a constitution that allows the judiciary to interpret constitutional provisions and bills of rights in accordance with treaty bodies and human rights mechanisms, then it's really advanced that conversation, both domestically and, you know, it advances both ways, because what's happening domestically is also translated to the treaty bodies in the review processes. And so therefore, I think this is a way in which treaty bodies understand the needs of states in relation to the guidance that they can provide. The second, I think, really important thing in relation to this relationship between what happens internationally and what happens domestically, particularly in relation to lawyers and judges and legal systems, is the creation of mandates like the Special Rapporteur on the Independence of Judges and Lawyers, the country visits of special procedures, the fact that every single special procedure, for instance, who's come to my country, Fiji, has asked to see the Chief Justice. And, you know, that means that, amazingly, every single mandate holder thinks that judges have everything to do with the implementation of human rights in relation to the whole spectrum of rights. And I think, so therefore, I think that special procedures and the other mechanisms of the Council have really helped to change the human rights landscape domestically and the world over. And the third is the Universal Periodic Review. We've seen the UPR change within itself. One of the complaints that some of the developing states make often to me is that we don't speak enough about our SESCA rights, about economic, social, and cultural rights. You know, have we got some sort of fixation with ICCPR rights and we've forgotten issues like the right to education and the right to health? And the COVID-19 pandemic tells us that, in fact, we ignore the right to health at our risks, at our considerable risk. So I think really the UPR process has transformed in itself to promote a greater equality in the kinds of recommendations made to states, which states accept. And in the implementation of those recommendations, we see a much better synergy between the human rights landscape internationally and domestically. Over to you, Schona.
Thank you for that very compelling answer. We're talking just in the aftermath now of COP26 here in the UK. And one of the questions I know some of our members will be interested in is, are we likely to see that sort of shifting dialogue on other areas that have been historically either overlooked or controversial, but are now becoming part of an ordinary everyday conversation? So, for example, climate change, business human rights issues, perhaps relating to supply chains. As you say, the language of human rights is perhaps divesting into other areas beyond the ICCPR. So what role do you think the Council will play in that shifting dialogue on, for example, environmental issues or business and human rights issues?
I think because the Council is a member state-driven process, much depends on the priorities of member states. And when we speak of climate change, we know that climate change is of particular importance to small island developing states and LDCs. So if we see a more representative council and we see more SIDS represented on the council, you will automatically see a much better dialogue on climate change. When Fiji first opened its mission in 2014, we were one of the first Pacific Island countries to open a mission at all in Geneva. But one of our priorities was to bring climate change to the Human Rights Council. And we adopted several strategies to do that. But you know, all of that came to a culmination just a few months ago when the Council adopted two important resolutions at a time when both Fiji and the Marshall Islands are members of the Council. And we have other SIDS, including the Bahamas, on the Council. And one resolution was on the recognition of the right to a healthy and sustainable environment, a clean, healthy, and sustainable environment, to be specific. And the second one was a resolution which created the mandate for a special rapporteur on climate change and human rights. And I really do believe that the voices of the small island states were compelling in this journey. From having no conversation at all on climate change and human rights, we have two resolutions which really bring home this important relationship between climate change and human rights. And I think part of the problem in the reluctance to discuss these new issues has been that in multilateral institutions, there are already other institutions talking about climate change. The difficulty is that the UNFCCC doesn't always talk about climate change and human rights. And the Human Rights Council has not always talked about climate change and human rights together. So how do we then promote a discussion which really demonstrates to the world that climate change is a human rights issue? And I think this more representative council, the sort of relentless pressure on the Human Rights Council to include climate change, for instance, through its UPR process, and the commitment of members of the council to accept that this is a human rights issue, has shown the flexibility of the council to respond to some of these more modern issues. The same with business and human rights. For a long time, human rights was a relationship between a government and an individual. But you know, we left out one of the most important players in this, and this is businesses, the corporate world, who can be responsible for the most gross human rights violations. And we know this now. And this led to the creation of the guidelines on business and human rights, which now has become accepted. It was adopted by consensus by the Human Rights Council and is now leading to change. Some would say not quickly enough, but I think it's leading to change and an acceptance of businesses have a very strong role in this conversation. Over to you.
Thank you very much. So there's been I think that's a very kind of helpful summary of some of the more positive aspects of progress that you've seen over your time at the Human Rights Council. But stepping back for a moment, and you talked about COVID-19 and the right to health and the other emerging sort of rights that have been very acutely felt, perhaps under a magnifying glass, sort of, over the course of the pandemic. But another aspect or feature of the pandemic has been that many human rights bodies and organizations have pointed to a worsening climate for human rights in the civil and political sense of the word over the last 2 years. So, for example, peaceful assembly, protest rights, and such like, freedom of expression, have been under attack in a number of different parts of the world. Do you think that the Human Rights Council has a role to play in highlighting those sorts of assaults on civil and political rights over the pandemic? And if so, how can it best do it?
I mean, the short answer is yes. It already has played this role. And, it's extraordinary that the Human Rights Council had to suspend temporarily its operations in March of last year because of the COVID-19 restrictions, but only to come back rather quickly in June. And one of the first things it did was to agree to a resolution on the relationship between COVID-19 and human rights. And since then, there has been a continuous stream of reports by the High Commissioner of Human Rights on how we are to relate to COVID-19 in our countries, and really issuing very strong warnings about the dangers of having far too restrictive laws and policies, using COVID-19 as a reason. And you point to some of them exactly in the way that the High Commissioner also has warned us. In addition to the High Commissioner's updates to the Council, which have been mandated by the Human Rights Council, the special procedures also have shown great flexibility and really speed in their responses, in the way that they have delivered reports to the Council about the relationship between COVID-19 and their specific rights. So certainly ICCPR rights, civil and political rights, but also, the Special Rapporteur on the right to food. And then there's been an extraordinary discussion on access to vaccines within countries and between and amongst countries. And that is a new discussion, but it's a discussion we had to have, because this is about ultimately equity, not just within our countries, but amongst the international community. And it's been an extraordinary conversation. I think it's demonstrated the ability of the Council to really speak about something that concerns us. But I do have to say that this relationship between rights and limitations to rights on the grounds of public health is one of the most important discussions this year, and certainly last year, and probably in the next few years, as we struggle in our countries to adapt our health systems with civil and political rights. So how we read these limitations, how we empower our legal professions to challenge limitations which go beyond the discourse of human rights and become far too restrictive. I think this is a very important role for the courts, but very important also for governments to understand that you can't pass laws willy-nilly because we are facing a pandemic. It's very important to continue to follow principles and international guidelines about how much you can restrict rights, what is justifiable in an emergency, and what is clearly not justifiable. I think the Human Rights Council has been central to this discussion, but even more importantly, the special procedures, which really have, many of the special procedures have expressed concern about the over-restrictive path that some countries have taken. Over to you, Schona.
Well, thank you very much. And on that note, I know that many BHRC members would like me to put to you a practical question, which is that there are a number of current or very recent member states on the Council whose own domestic human rights practices are the cause of very serious concern and criticism. And in fact, many of those states appear to be repeatedly elected, despite being perhaps as far as possible from the very high standards or the higher standards that the body sets for itself. And there are some good examples of that. And perhaps I'd like to take you to a couple of them, but I wonder if generally you might have a view on that.
I think we really need to look at that issue in two ways. One is the political. one of the criticisms of the predecessor to the Human Rights Council, the Human Rights Commission, was criticized at the highest level, including by the former Secretary General of the United Nations, as, having embraced members of the Commission which had really serious human rights violations in those countries, and some which had taken leadership in the Council. And of course, that's always a matter of concern, because the leadership of the Council is absolutely crucial. It's a global role. Also, there was concern about the way in which members were elected onto the Commission. So it was often done by regional groups. They would agree to a clean slate. These were the members who were going to become members of the group, who were going to become members of the Council, and they would just be elected almost as a matter of form. And that was considered to be a weakness of the Commission. In order to try and rectify that particular position, the Council has, first of all, a smaller membership, only 47, as opposed to the 53 under the Commission. Secondly, your human rights record as a country is an important consideration for election. And thirdly, the ECOSOC is not the superior body to the Council. It is now the General Assembly for the Human Rights Council. And so therefore, when you go for election as a member of the Council, you are required to really justify your membership, not just in terms of your geographical representation, but also in relation to your human rights record. So that sounds really good in principle, except that there is a current practice where we still have a clean slate, where regional groups do put forward or countries put forward their candidacies on the basis of a clean slate. So really you have no real choice but to elect those countries, even though you might have concerns about their human rights record. But if you look at the voting record for the Council membership every year, you will see that despite a clean slate, not all countries have the same votes. So member states of the General Assembly are choosing not to vote for countries if they have concerns about human rights records, even though there may be a clean slate. And I think that's a very positive step, because it shows that there is a sense of clarity and a sense of judgment in the voting process. The second point that I want to make in relation to the membership of the Council, and that is, if we were to say that only if you have no human rights violations in your country can you justify membership of the Council, let me say very, very clearly, we would have no members on the Council. Because I consider sitting day after day in the Council, listening to the reports of the special risk procedures, listening to the UPR process, I know that every country has human rights challenges. And we all need to work a lot harder, certainly in some areas. So what might be a migration challenge for one country would be less of a challenge for another country. For another country, it might be not being able to deliver on civil and political rights. So I think, how do we make this map of diversity a strength of the Council and not a weakness? And I would say this, that if our debates celebrate and embrace freedom of expression within the debate, so that countries are able to say, actually, I think we should now talk about, for instance, the impact of racism on the delivery of human rights in our countries. And actually, let's talk about access to vaccines. Then I think you will find that diversity is capable of being a strength. And, we have to remember also that no one country in the Council has the powers of veto. We are not the Security Council. Nobody can freeze the discussions by simply raising a power of veto. And if there continues to be disagreement on any human rights issue, which requires a decision by the Council, then we take a vote. And I consider our ability to make decisions democratically, I think this ability is really a very strong answer to those who might be concerned that there are some countries on the Council which have more human rights violations than other countries, for instance. I think it's very important that we enable a democratic process of voting, and we do by the modalities which have been adopted by the General Assembly. Over to you, Schona.
Ambassador, I suppose one of the sort of most obvious retorts to that question of democratic accountability on the Council is the question of what happens if a state wants to subvert or effectively gridlock a conversation on human rights altogether. And so one example that I wanted to specifically pose, and you may or may not be able to answer it, relates to China. But I know BHRC, amongst some of our other organisations joining us today, have done a lot of work on the multiple growing allegations of atrocity crimes in Xinjiang. And what we've seen is a pattern of block voting on the Council or block actions that potentially subvert any protection or promotion of human rights, both at a dialogue level and at a geopolitical level. So, for example, China in last year, I think it gathered together 53 countries, including 13 council states, to defend its interventions on Hong Kong. And there has been something similar on Xinjiang in 2019. So I suppose the question is the Council able to deal with attempts to subvert or to gridlock the progress that has been made on human rights that you point to?
Well, I think with joint statements, we have to remember that joint statements are a part of the debate, but they are not the decision. The decisions of the Council are gavelled, and those are passed by resolution. So in relation to any country, and it's not my practice to single out any particular country in any of the discussions that I have, but I think in relation to any country, the question is, are there enough member states of the Council who think that a particular human rights situation is of sufficient concern that they will now move towards the negotiation of a resolution, which is a decision of the Council? And of course, it's always very nice to have a consensus-driven resolution. Everybody wants a resolution passed by consensus, but I'm a multilateralist. And I know that there is a point at which during the negotiations, the countries who are the core group and sponsoring the resolution will say, no, we're not going to compromise anymore. This is the red line. I'm sorry, we're not going to compromise, and we will rather give up the prospect of a consensus in order to have a decision, which means we'll go for a vote. And so then the only issue on any country-specific situation is there enough support for a resolution? And for this, I have watched months and years of the way that states negotiate successful resolutions and the way in which they are able to get a decision passed by the Council in some of the most difficult areas of the world. And I really do think that you can certainly influence the debate by joint statements or by issuing a joint statement of your own. But a joint statement is not a decision. And so actually, one state cannot freeze the dialogue. It may influence the discussion, but it cannot freeze the dialogue. And if enough member states want a resolution and a decision, the Council will make a decision. And I think this is one of the greatest strengths of the Council. And I think the way the negotiations work, and I do have to add here, the important role of civil society in the open-ended consultations for the negotiations, I think this has really contributed enormously to some very difficult resolutions passed by the Council, not just this year, but for several years.
Thank you very much for answering that question. And I think a feature of that same point is this question about reshaping or remolding the human rights dialogue and the extent to which states can try to do that by their place on the Council and through this block voting. Is there a danger that that in the new geopolitical era that we are now in, that the language and the vision of human rights that was initially used to set up the kind of international institutions that we have in the 20th and into the 21st century will become too gravely damaged by this attempt to reframe human rights in a narrow domestic way?
I don't think that it will be so gravely damaged that in effect, the discourse on human rights is either damaged or frustrated altogether. And call me a dangerous optimist, but I have seen so much positive progress, as I've said, on some very difficult discussions, and discussions where we thought the majority of the members of the council would resist something. And actually, through the course of negotiations, they all came on board. And I have to give as an example the discussion about the right to a safe and healthy environment. I did not get a feeling about a year ago that the majority of the council would support that resolution. Firstly, there were many council members who thought that we should discuss the environment somewhere else and not in Geneva. And secondly, there were fears that we were creating too many mandates, and there's already and there's already too much discussion about the environment. We're already going for a special rapporteur on climate change. So really the right to a safe and healthy environment was slightly dangerous as a separate right. And when put together with the creation of a new mandate holder, well, we were doing far too much. This was the discussion I was hearing only a year ago. And yet in 1 year, there was a very strong acceptance of both resolutions, the creation of a new mandate as well as the creation of a new right. And I see that journey as one which shows that actually block voting may not be the language of the future, because I couldn't see any patterns in the room. I mean, you could say, all right, all the European Union countries are going to vote in a particular way, but in some resolutions they haven't all voted in a particular way. And with the OIC, the Organization of Islamic Cooperation, again, they sometimes break ranks on several issues. And at the end of the day, of course, it's instructions from your capital, but I think a great deal must be put at the door of these multilateral conversations we're having. And the extraordinary set of ambassadors we have in Geneva, this ability to have discussions which are difficult, which are controversial, and yet we've been able to pass very, very challenging resolutions. So I am an optimist, and I believe that the work of the council justifies it. Over to you.
Thank you very much. Well, I'm going to slightly shift the topic of the conversation now to a more general one, but no less important, about the nature of representation at the council. And I think it is true to say that there remain very few women with seats at the table in international fora generally. Can there be any credible international human rights movement without equal numbers of women shaping the debate, the visions and actions of states? And should the Human Rights Council, and indeed the UN, be actively promoting and aspiring towards a feminist foreign policy?
Well, I think the answer is that no institution can have credibility if it doesn't have diversity. And if that institution doesn't look like the community it serves. So I think my position is very clear that gender equality is central to human rights development everywhere. And in relation to specific human rights, if you don't have a gender focus on the way that that right relates to gender equality, I think then we haven't even done the work that is required of the global human rights community. So I think we've got an awfully long journey yet on gender equality. The Human Rights Council has a gender focal point appointed by a previous president and who was extended by me this year. She is the permanent representative of Angola. She's extremely strong and very, very committed to gender equality. And she did tell us this year that whilst she thought that COVID-19 might allow more women to engage at the council, because we have virtual representation, people don't have to be paid for by their countries to come to Geneva or to get visas and so on. Actually, that should have seen greater access for women. But unfortunately, this was not the case. So I'm afraid that gender inequality at the council continues to be challenging. We still have more men than women representing delegations. And we continue to encourage delegations to remember gender parity in representation. we have had this year a bureau which was largely women. Until only last month, when we had the new ambassador of the Netherlands joining us, we had only one man on the bureau, the ambassador of Bulgaria, who is a committed feminist. So we are assured that he would continue to work with us on gender parity. But it's not enough. It's not enough because actually leadership is not representative of general equality. It is the start, because then the image is good, but I'm only the third woman to be the president of the Human Rights Council. And even that, I think, is work in progress. I think we need to continue pushing for gender parity at the highest level, so at presidency level. I think there's a very strong role for the gender focal point continuously. And I think we need to continue to emphasize this at every opportunity that we have in the work of the Council. The second, I think, is to look at the substantive work of the Council. Is every special procedures mandate holder able to do his or her work in a way that's gender aware? So when you're talking about the right to development, is there a very good report on the effect of development on women and how women get left behind on development journeys? On access to vaccines, have we acknowledged the fact that women may not have the same access as men to vaccines? In the right to education, are we acknowledging that girls are not going to school as much as boys are? And in the digital divide, when we are going online for education, do we acknowledge the fact that perhaps girls do not have a laptop or a smartphone and therefore are deprived of education at a very fundamental level? And deprivation of the right to education for girls and women means a deprivation of every other right. So I think, you're absolutely right. We are nowhere near where we need to be, and we have to keep pushing. And until we get to the kind of gender parity we would like, then I think we have a legitimacy problem with every institution. I have to say, though, that we have made some progress this year on the appointment of special mandate holders. We finally have 51% female mandate holders. And that is because I believe that the work program and the methods of the appointment of mandate holders has got a strong focus on gender parity and geographical representation, but on gender parity. So the consultative group, which is responsible for shortlisting and recommending special mandate holders, is specifically tasked to look at gender parity. So we have made progress in that area, I'm very pleased to say. Over to you.
Thank you very much. Well, as many more questions as I may have for you, I'm seeing some pouring in now into the Q&A from our audience, and I'd like to put some of those questions to you. The first question is about human rights defenders generally, I think. It's this: how do you see the impact of shrinking civic space on the work of the Human Rights Council? And it goes on to explain, as we know, in several countries today, there are serious impediments imposed on the work of human rights defenders and CSOs overall, from threats and intimidation to the use of surveillance. Of course, we saw human rights defenders very recently impacted by the Pegasus scandal in various countries. And we also know that there has been a real and serious shrinkage of civil space afforded in a number of countries, some of whom are states on the council. So perhaps you could address that question.
I think that civil space in many countries is shrinking. And I think that we should be very grateful, particularly to civil society advocates and representatives who come to the council and are consistently reminding us not only that civil society space is shrinking, but how we can help to ensure that the voices of civil society continue to be heard in a qualitatively effective way. And I think in a way that the fact that we've had virtual Human Rights Council sessions this year, that we have allowed video statements for civil society and enabled their voices to be heard through video statements has been very helpful, because for the first time, I think we're having a larger number of human rights defenders speaking at the council from the field. Those who might not, for instance, have been able to get a visa to come to Switzerland, or who might have travel restrictions because of COVID. We're hearing their voices much more. And I think this is a strength of the accessibility of the council because of the virtual modalities. But I think also we have to accept the fact that there needs to be a very good and strong conversation at the Council protecting civil human rights defenders from reprisals, particularly in relation to those human rights defenders who have cooperated with the mechanisms of the Council. And secondly, to ensure that in our resolutions, we acknowledge the need to protect civil society space. So if I take the second issue first, the resolutions on protecting human rights defenders, and also specifically environmental human rights defenders, have really gathered a lot of support at the Council. And the last resolution on reprisals and the prevention of reprisals, and I have to say I've always taken a very close interest in this particular resolution because my country is in the core group of the resolution on reprisals. The last resolution on reprisals for the first time was adopted by consensus. So, I mean, I think that is very good progress because there seems to be no real strong objection that, we should in any way have a system which might encourage reprisals against those who defend human rights. But in relation to the voices of civil society and in relation to the work of the Council, one of the strengths of the Council is the voice of civil society. In fact, I think that one of the most important things about Council is that in debates, we're hearing the voices of civil society in relation to a particular debate, and we're hearing very clear voices. And these voices are telling us about incidents which may not come up in the course of the state debate, the state portion of the debate. I think it's one of the strengths of the Council. I call civil society the conscience of the Council, because I think civil society is constantly reminding us about the real reason and the point of the Council. And that's for the people of the world. We're not there because this is some sort of form of respectability. This is because the people of the world really need to have this relationship between what we do in Geneva and what we do in individual countries. Civil society is absolutely crucial in that conversation, as it is in every conversation about all human rights. I consider that the work that civil society groups do is dangerous in many countries. Many human rights defenders have died and have been killed because of the work that they do. So this is a matter of great seriousness for the Council. And I think that if we were to ignore that historical reality, we would, I think, lose a great deal of legitimacy. Over to you, Schona.
Thank you very much for that. And I think a follow-up to that would be, I think the follow-up to that may be a question about the integrity of the Council in a situation where those sorts of allegations come to the door of a Council member state. And to that end, I have to mention the case of Jamal Khashoggi. And Saudi Arabia, of course, was sitting on the Council in 2019 when the UN investigation led by Agnes Callamard found that his murder constituted an extrajudicial killing for which Saudi Arabia was responsible. And I wonder how the integrity and influence of the Council is maintained in the face of a member state that has allegations brought to it like that.
I think, I go back to the earlier question you asked me about the membership of the Council. And the membership of the Council is one which the General Assembly needs to continuously be aware of in the election process. But this is a political process. When you have an election process in the General Assembly, this is a political process. And the member states of the United Nations make political choices as to who should be on the Council. So this is not a matter over which the Council itself has control. This is a political process. But again, I say, as I said in relation to the earlier question you asked about China, I say this, that enough member states which consider any particular human rights situation anywhere in the world to be a matter of concern, if they get enough support, they can move the Council for a decision. And it really is a member state driven process. Over to you.
Thank you very much. I have another question about the state's ability to impose limitations or derogations from human rights standards. And Ambassador, you're being asked, do you think there are gaps in standards, and do standards like Siracusa still help?
I think Siracusa has been really important in COVID, in the midst of COVID. And I know that in regional consultations and discussions in my own region in the Pacific, Siracusa has been central to the question of how much you can limit rights in a health emergency. And we will continue to look at those guidelines. We will continue to look at all the laws on how you read rights and limitations in human rights in order to really help our communities. Now, of course, they also help our governments. And governments have human rights experts in their attorney general's offices and so on, who are supposed to say to government, no, you can't actually pass that law because that limitation is too excessive. And hopefully they are assisted by the international guidelines that we have. I think they continue to be relevant. And ultimately, it does depend, in the passing of laws, it does depend on the government concerned as to whether they think it's important enough to water down the limitations which are included in their legislative framework. But you know, if there is a gap, then I have the greatest faith in the legal professions around the world to take these matters either to court or to the human rights commissions, which is where human rights commissions of so much importance, to try to ensure that there is more universal compliance with the standards that guide the relationship between rights and limitations. One of the most important issues, I think, that face the world. How do you read rights? How do you read limitations? What is justifiable? What is proportionate? And what is, allowed by law? So I think relevant, yes. I think a lot more work, and I would put human rights commissions, field officers of OHCHR, and the legal professions right in the midst of that conversation to ensure in continuing relevance. Over to you.
Thank you very much. Well, that leads me, I think, to my next question, which is most of the people in the audience today are either lawyers, civil society, or human rights defenders. And the question is, how do we bridge the gap that sometimes appears between a supranational institution like the Human Rights Council and lawyers, civil society, and defenders at a domestic level? So how can we try to bridge the gap? How can local organisations and lawyers become more involved in the work of the Human Rights Council? But also related to that, how can we ensure that there is a sufficiently representative cross-section of human rights organisations represented in the UN system?
As far as how we ensure this stronger relationship between the global human rights world and the implementation of human rights on the ground, this is a subject that I have spoken about at length in numerous fora. And my view is we need to do an awful lot more work. We need to empower more judiciaries to be aware of the implementation of human rights using international standards. So for example, if you're looking at prison conditions, how you encourage judiciaries to use the United Nations minimum standard rules, the Mandela rules, on really assessing whether or not their local prison conditions are satisfactory and are consistent with human rights law. Similarly, if you're looking at, for instance, the detention of children, how do you assess that those detention conditions are consistent with human rights law? There are two difficulties with that conversation. One is, does the domestic legal framework permit the use of international law and international work in the interpretation of a particular right? And some countries resist this. Some countries specifically say, that's very good. You're having this conversation in Geneva, but we are guided by our own constitution, our own laws. And, what you do in Geneva may be generally helpful and influential, but we're not going to interpret our laws in accordance with the treaty bodies, for instance. That is a real barrier to effective implementation. Secondly, I think that training is absolutely key. And I put a great deal of emphasis on the need to train judiciaries and the legal profession on the application of human rights. I've said this before. When a lawyer takes a human rights case to court, generally speaking, the person who is the defendant is the government or government agency. And there isn't a great deal of money to fund the lawyer who is taking this case to court. The person who is the litigant is usually one of the most vulnerable person in society and doesn't have a lot of funds to pay for lawyers and so on. So this act of challenging human rights violations in court is not just an act of great courage. It also requires a great deal of knowledge about the interpretation of that particular right. And you don't want to be knocked out on a process because you got the procedure wrong. So lawyers who are extremely careful about the way in which they file affidavits, ensuring the proper evidence is before court, who know exactly how to make an application for constitutional redress, who know what remedies they need, which are useful for the litigant. This is the kind of training that I think a lot more effort needs to go into around the world, because courage is, I think, at the top of the list in these cases, but also knowledge of human rights law and the way that it may be used in the domestic jurisdiction. Over to you, Schona.
Thank you very much. I'm running out of time, I'm afraid, to ask all the various questions that we've got. There is one question that I would like to ask just before we reach the end, that I know a number of BHRC members have asked me to ask, which is this: how do we get the Human Rights Council and other agencies of the UN to act proactively against human rights abuses rather than reactively when the worst has ever happened? Put it another way, what good is the UN Human Rights Council after the event if it can't react to the unfolding situations that we've seen, for example, in Myanmar, in Xinjiang, or even Tigray?
I think that's a really, really important question. And it's a question about the prevention agenda of the Council. The Council is not intended to be a council which responds to the most serious human rights violations when it's already done. And we see the most dreadful images in the media. Actually, the Human Rights Council is supposed to act as an early warning mechanism so that we identify all the ways in which a human rights situation in a country might escalate to something which is so difficult to deal with that we end up with a special session. So as you know, we have special sessions in the Council, and this is to address the worst violations. Again, it's a member state driven process. You get a number of countries together who ask for a special session. The letter is written to the Council President, and then with between 2 to 5 days, a special session must be held. And it's an emergency and an immediate response. But by this time, of course, the human rights situation in that country has become so bad that the only thing that will be left for us to do is to appoint some sort of fact-finding mechanism or a commission of inquiry to investigate with a view to prosecuting in the future with a referral, for instance, to the ICC. So the early warning mechanisms are the special procedures who visit countries, who work in a constructive and collaborative way with countries, and who point out all the difficulties in rolling out human rights in countries, which that country should really consider as recommendations made in the best interest of the human rights journey of that country. And I have, again, the greatest faith in the work that the mandate holders do. They go to some of the most developed countries in the world and they warn those countries. If you don't keep an eye on your immigration laws, for instance, or on racism or on diversity issues, then you're really looking at a very serious social problem. So it's an early warning mechanism. The other early warning mechanism is the UPR. That's a 4-year cycle. So that when you make a recommendation, so for instance, if the United Kingdom were to make a recommendation to Fiji to say, please, you have a problem with albinism, and you haven't got, for instance, a national plan on albinism. Then if Fiji accepts the recommendation, then it must, within the next 4 years, deliver on implementation. And it's a good way in which, in a very collaborative and constructive conversation, countries are able to really keep an eye on issues which might escalate. And I'm not saying that albinism would escalate, but you could imagine many other human rights issues which might escalate without an early warning sign. Of course, we know that some countries will simply ignore the recommendations made by the mandate holders or the treaty bodies or the UPR. This is true. And it's then, of course, that we have very serious conversations in the Council and start to appoint fact-finding missions and mechanisms to investigate with a view to referring matters to the ICC, for instance. But I've also seen the removal of some country situations from an item on the agenda, which is an item which asks for fact-finding mission and for reports and for investigation, to the far more collaborative technical support and capacity building item 10, where the country agrees to a program, usually led by the OHCHR and the High Commissioner, where the country works together with the High Commissioner to promote particular human rights and to really deal with human rights violations in the past. And in this item 10, we have seen the creation of transitional courts. We have seen the creation of systems domestically where there is greater collaboration, and I think a very effective early warning system. Do we talk enough about the prevention agenda of the Human Rights Council? I don't think we do, but I think it's one of the most important aspects of the work that the Council does. Thank you very much.
Ambassador, thank you very much for your very honest and thoughtful reflections with this conversation where there were no holds barred. We have unbelievably run out of time. The hour has flown past. And so I wanted to thank you very much on behalf of BHRC and behalf of all the various audience members who have joined us today. And I wonder perhaps just in a moment of reflection at the very end of this, whether you might answer a question that I myself am so often asked, which is that we are facing dark times. For human rights lawyers and defenders, it feels in many, many parts of the world that we are in dark times. Is there any light ahead?
Again, I salute every single lawyer and human rights defender who is committed to really making transformative change in a situation or in a country or in a region. As I've said, it takes greatest courage. But I think there is light ahead. And I think the light is in increasing synergy between the work of the human rights mechanisms and domestic jurisdictions. And I also think that there is a very important role here for lawyers and judges to really advance this conversation on human rights. As long as we have independent judges and an independent bar with this courage and ability and determination to really make a difference, I think we are looking at transformative change. Over to you.
Ambassador Khan, thank you so much for joining us. It's been an honor and a privilege. And thank you to all of our attendees today. I'm sorry that we didn't have a chance to answer all the questions.
Thank you so much. Bye-bye then.
Thank you. Bye-bye. Bye-bye.